Welcome to all of those who are joining us online. For those of you who don't know, this is the first hybrid program we've done, in which we have an in-person audience as well as those joining us online for our webinar. This webinar is part of the Civil Justice Academy of the Law and Economics Center at George Mason University's Antonin Scalia Law School. The Law and Economics Center is committed to high-quality educational programming that helps decision makers better understand economics so that they can incorporate the insights from economics into decision-making, into their analysis so that it becomes more rigorous and better informed. And so our Civil Justice Academy runs these webinars and panels. Now we're getting back to some of the live in-person ones as well on a regular basis to highlight issues in the area of civil justice where economics plays a role. And as with each year, we try to invite experts to come and talk to us about the upcoming Supreme Court term. And so today we have our Supreme Court preview of the upcoming October 2023 term. And we're delighted to welcome two experts who are well experienced in litigating before the Supreme Court, as well as working on other issues of critical importance in civil justice. And we're, to save time, I'm not going to give extensive bios, but instead just introduce them. And I do encourage you to look up their work and follow it by looking at the email with their bios linked in that we sent you with this invitation. But we have on my far left John Beisner. John is a partner at Skadden, Arps, Meagher, and Skadden, Arps. I always forget the whole name, but partner at Skadden. He is going to talk to you about several cases today, and each of our speakers will be talking about the cases and responding to each other on that. Bob Peck is the founder and president of the Center for Constitutional Litigation, and as I mentioned, also an experienced litigator in front of the Supreme Court. So we're going to get right into the cases. And to wake you all up and get you excited right away, we're going to start with bankruptcy. So I'll turn it over to Bob Peck to get us going.
Well, thank you, Donald. I want to thank Donald and the Law and Economics Center for inviting me again to participate in this event. It's always fun to be here, to join my far left partner, John, and talk about this obscure federal agency that's rarely in the news. So the Purdue Farmer case, Harrington versus Purdue Farmer, is an outgrowth of the opioid crisis. So if you've been watching Netflix, you've seen the various programs that have been based on this, movies and TV series. And you know that some 270,000 people died over a period of 20 years connected to the opioid crisis. It's become massive litigation, and one of the defendants is Purdue Farmer, which was most responsible for OxyContin. So the Sacklers, who were the owners of Purdue Farmer, basically took $11 million out of the company, put it in overseas along with most of their assets, and leaving only about 25% of the assets there. Purdue then applied for bankruptcy as part of this litigation. The Sacklers then were clearly trying to avoid having to be responsible in any way for this. So the settlement that was proposed would be that Purdue Pharma would become an abatement company. It would no longer produce pharmaceuticals, but it would be seeking to help abate the opioid crisis. That would be its function. It would take its assets to do that, and to escape any personal liability, the Sacklers offered to put up to $6 billion into it as part of an overall bankruptcy settlement. So the issue for the Supreme Court is whether a non-party, someone who has not applied or filed for bankruptcy, can be included in the settlement and essentially escape liability in this fashion. Does the bankruptcy code permit it? Harrington, who is the U.S. trustee in this, is represented, of course, by the United States, and as a result, was arguing that there is nothing in the bankruptcy code that authorizes this. So it's a pure textual approach to it, saying that it wasn't intended to do this. It was intended simply to try to make sure that whatever assets a bankrupt company has would be available to its creditors. It's required to name all its creditors and do all these different things, which obviously does not apply to the sacklers, and also clearly also cuts out a lot of the claimants of opiates who otherwise are not part of this process. On the other hand, the response that Purdue has put in is basically that there's nothing in the bankruptcy code that forbids this type of arrangement. And so therefore silence is what allows them to be creative in this fashion, and allows them also to ensure that there's something that goes to address the opiate crisis and the claimants. Without this kind of an arrangement, basically their contention is that the claimants will be out of luck entirely. So with that basic description of it and the arguments back and forth, turn it over to you, John.
Well, I'm not sure I have much to add to Bob's fundamental analysis of the case. I think most commentators are predicting that given the speed with which the court acted to take on this case, in fact, as I recall, there really wasn't a cert petition formally filed. The Solicitor General asked to stay the settlement, and the court just basically said, yeah, we're going to take the case. And so it sort of signals that the court probably is inclined to overturn this deal. And there are arguments, as Bob is suggesting, that those in the court that have a plain inclination and saying, if there's nothing in the statute, how can you do this, may be inclined in this position, but we will see. One thing, though, I did want to note is that the advocate here really is, as Bob indicated, the U.S. trustee. And the plaintiff's side is fundamentally supporting the deal. They don't want the Supreme Court to overturn this. It's an amicus brief filed on behalf of 60,000 personal injury plaintiffs. Purportedly, I have no idea what the background is of that, but purportedly on behalf of them saying, Supreme Court, let this deal go through. We like it, we want it, we approved it, it went through the bankruptcy process, everybody voted on it, and it won approval. Meanwhile, you've got governmental entities that are part of the settlement, namely states. There's a large number of state attorneys general who have filed briefly saying, we want this brief, we want this settlement to go through, we want this to be maintained. So it's an odd situation where the real parties in interest are all aligned saying, don't disturb this, and you have the U.S. trustee in position saying that you need to interpret the statute this way, presumably because of concern about future deals. But
Can I ask the speaker to hold the mic up?
I'm sorry, yes. And in any event, if the trustee prevails, it may delay or effectively mean there is no settlement because everyone would have to start over. The second thing I'd note is that the commentators may be right about the statutory language in the bankruptcy code and so on, but I do have some concern about this avenue being cut off because mass tort cases are taking over our federal court system. Most of them get resolved without resort in any way to the bankruptcy process, if they are resolved through the settlement. But there are circumstances where this is the only path. And the one thing I note is, when I go to settle a mass tort case that's not in bankruptcy, you always get a third-party release from those who are agreeing to the settlement. And the simple reason is, if I'm company X and I pay all this money to settle it, I don't want this plaintiff with whom I'm entering into the settlement to come back later and sue a doctor or sue a pharmacist or sue some other person who is involved, allegedly involved in the injury sustained, to file a lawsuit, because then they will bring me, who's already paid all this money, back into the litigation. And so it is not that unusual to have a third-party release. And when companies settle these cases, they don't ask the doctor or the hospital or anybody else to pay anything. They just get it because they don't want to pay this money and have the litigation continue. And so the notion of a third-party release per se is that not that out of line, but as Bob indicated, I think it's the facts of this case are different than you're seeing in most circumstances. So
If I can add just one thing.
Sure.
One of the arguments that Purdue makes is that bankruptcy courts are equity courts, courts of equity, and so therefore they have some power to go beyond the literal words of the statute. Now, of course, there is the other fear that this will lead to everyone just going to bankruptcy court instead of what seems to be the common approach of MDLs. And so it would be a major shift in the way that the litigation system works. So the court's going to have to weigh all those things and decide whether or not the bankruptcy code allows a little play in the joints in this fashion.
Well, with that, I'll move on to our next case, and I will say at the outset that I love this case. And I love this case not so much because of the legal issues presented, but the procedural history is beyond belief. It's just a very fun factual history in this case. The question presented in this case is, does a tester have standing? And if you're like me, when I first encountered this, I said, what the heck is a tester? And apparently there's a cottage industry of folks out there who comb the internet reviewing the websites of hotels, inns, and other similar establishments. And why do they do that? Well, the Americans with Disabilities Act requires hotels to post on their websites information about the accessibility of the physical plant of the establishment. And testers scan these websites, and if they find one that's non-compliant, they dispatch a lawyer with whom they usually have a standing relationship to file an action against that establishment. And the issue is that usually the tester has no intention of going to that establishment. They just file the lawsuit. And apparently the business model is, and I don't have personal knowledge of this, but the suggested paper that the business model is that the tester will then get money from the lawyer out of whatever recovery is obtained. In this case, the tester was a woman named Deborah Lawfer. She does have physical disabilities and vision impairments, so she is within the protected group of the statute. She has personally brought over 600 lawsuits against hotels asserting website non-compliance allegations. And in this case, she filed a lawsuit in federal district court in Maine against the owner of an inn located in Maine, alleging these ADA non-compliance points. And the district court tossed the lawsuit, agreeing that Lawfer lacked standing because she had no plans to visit the hotel and therefore was not injured. One detail that I should know. First interesting fact, Ms. Lawfer lives in Florida. The judge made inquiry at some point, well, how can you have standing? She said, oh, I plan to drive to Maine to try out this place. And somewhere along the line, it came to the court's attention that she had filed lawsuits in 10 other jurisdictions the same day, and therefore he found it not credible that she would plan to drive to all of these different places. And ultimately, Lawfer conceded the point that no, she didn't intend to go there. On appeal, the First Circuit reversed and reinstated the action. The circuit relied on the Supreme Court's 1982 decision in a case called Havens Realty Corporation. And in that case, testers operating under similar facts were found to have standing. Now, in that case, these were testers who were bringing actions for discriminatory representations about housing availability under the Fair Housing Act. So different statute, but similar idea for these lawsuits. Now, the defendant then petitioned for cert on the basis of a very substantial circuit split, which amazed me. In fact, factually similar cases, the First and 11th Circuits had concluded that there was standing, although they got at it in different ways. The 2nd, 5th, and 10th Circuits concluded that standing did not exist, and then there was cases in the 4th, 6th, and 7th Circuits that standing did not exist if the tester was visually impaired. Now, the fascinating aspect of this case is that when I went to look at the index of citations for the case, I came to the realization that there was one name omnipresent on the page, and it was law firm. And this one plaintiff single-handedly created most of this conflict. Her name is on the circuit decisions I just referenced from the 1st, 2nd, 5th, 10th, and 11th circuits. So this is a major split created all by one person. Now, initially, Lawfer filed no response to the cert petition. The court then asked for one. Lawfer's counsel asked for 2 postponements, 2 extensions before filing it. And then finally filed a response saying, bring it on. I don't oppose cert. I want the court to hear this case, and you should affirm the First Circuit. So that's another kind of unusual, you don't see that very often. The later development is that Lawfer's now filed a motion seeking dismissal of the case before the court on the basis of a suggestion of mootness. And in the filing, Lawfer's counsel advised the court that she was dismissing her case because an attorney who's somehow tangentially involved in her representation was recently sanctioned by the Federal District Court in Maryland for, and I'll just leave it at, wrongdoing in the prosecution of these cases for allegations of misrepresentations to defendants to get settlements and so on. And it was a little unclear to me exactly what the connection is, but I think that the lawyer who had been representing her was connected to this lawyer. And so she said, I'm basically filed a statement, I'm getting out of this business. She dismissed the case in Maine. And oh, the other thing I should note is the other thing that came out in Maryland is that an investigator for whom payments were being recovered apparently was found not to have done any work and was the father of plaintiff Lawfer's granddaughter. So a lot of connections there, but I'll just leave it at that. Supreme Court fairly quickly issued a concurring order saying, no, we're going to go ahead and hear this case, no explanation, but presumably based on arguments that there are lots of these cases and the issues likely to recur. But they did note that the mootness issue could be raised at an oral argument. So on the merits, I think the tension here is whether the court will reinforce older standing cases like Havens Realty, which seems that a person's failure to receive information that is required by a statute, whether that's enough to create standing without showing any injurious consequences from that. On the other side of that tension will be the court's more recent decisions, such as the 2021 TransUnion decision holding that standing exists only where one shows downstream consequences, as the phrase has been used, from a failure to receive statutorily required information. I'm inclined to think the court will follow the TransUnion route, but that remains to be seen, and we'll get a hint about that quickly because it's going to be argued the first week of the term.
So each term, there is one case, at least, in which the court does dismiss as improvidently granted, let's say, what's known in the business as a dig. I think this is your best candidate for that this year, because besides the basis that John described for mootness, there is other reasons to consider this moot. Number one, the lawsuit was based on the fact that the website did not reveal whether it was accessible or not. In August, the website was changed to indicate that it was accessible. The owner of the Atchison Hotel has sold it, and so no longer has an interest in that particular hotel and what's going on, but has filed to say that, well, she now owns a different bed and breakfast, and she's concerned it could be applied to her against that. That's not usually grounds for standing. And besides that, given the oddness that John so much enjoyed about the facts in this case, and given the recent back and forth on the court about standing, whether or not it should have granted standing in the 303 creative case, whether or not it should have granted standing in the student loan case, its refusal to grant standing in a number of other cases. At the moment, the best you can say about standing is when the court wants to decide a case, they're standing. When they don't, there isn't. I say this from the background of having argued a standing case in which I relied on Havens, which I won in 2017 on behalf of the city of Miami, which sued Bank of America and Wells Fargo for violations of the Fair Housing Act. And the question there was whether Miami would have standing. And Havens was a case in which basically an organization that used testers under the Fair Housing Act, the question is whether or not those testers really did have standing to bring this lawsuit. So they would send in a minority applicant to rent an apartment to a building, would be told that there are no vacancies and cannot be rented. And then an hour later, someone else who was white would come to the same building and seek to rent an apartment and was told there are 3 or 4 that you can choose from. So that was the basis on which to find that there was indeed racial discrimination going on in the rental of these apartments. So testing is something that's been used under the Fair Housing Act with some frequency. And in this instance, the plaintiff is someone who's also confined to a wheelchair. She, in her testimony, indicates that she used to sometimes go to hotels, discover that they were inaccessible, and end up having to sleep in her car because she could not get into the hotel or something like that. Now, whether that's true or not, this is apparently what set her off on this new career. And so clearly this is an abuse of that process. But the question, of course, is, how else, when you cannot find an agency that has the resources to enforce the law, do you do it, especially if there is a private cause of action? And so those are some of the issues that have to weigh. As John indicated, most of the case law on both sides involves this one plaintiff, and I think that's also going to encourage the court to dismiss as improvidently granted.
Thank you both. So I just want to interrupt for one quick sec. We will be taking questions at the end, so please store up your questions, and they can be on any of the cases. Our objective here is to give you an overview. Obviously, only a survey of the cases. We could talk much more deeply about every one of them, but we hope to give you a representative overview of some of the critical cases that you're going to hear about. But we will reserve time at the end, and for those of you online, please use the Q&A function at the bottom of your screen. I've got a tablet here. I'll be monitoring those questions, and I will incorporate those with the live questions when we get to that segment of the program. So I think we're now going to move into administrative law for a little bit.
Right, so if bankruptcy didn't exactly rock your boat, it's possible that administrative law might not either. But we have 2 cases that essentially are ways to re-examine whether the New Deal is constitutional. In the first, it's called Loper versus Bright Enterprises versus Raimondo, and it directly challenges whether the Chevron doctrine remains valid. It has been controversial. We've certainly heard from a number of justices that they are prepared to undo the doctrine, and certainly the briefing in the case by the petitioner is a full-throated attack on Chevron. It's unworkable, unanchored in anything that the court might really consider, and so therefore should not be a basis for this. If I can reopen my notes here, fading on me. There we go. The United States, you should understand, Chevron basically says that if an agency interpretation to fill in blanks in a statute is reasonable and is the product of either adjudication or something that has the force and effect of law, then the agency will be given substantial discretion to fill in that gap. There is another form of discretion called skid board discretion, which applies to opinion letters, agency manuals, things like that, which gets less respect from the judiciary simply because it does not have a force and effect of law. And in fact, I had a case a few years ago in the 11th Circuit in which we challenged the Medicare manual because it prevented the kind of result that we wanted in our case, and the court found that it did not deserve any deference. So the United States, of course, says that this is absolutely necessary, that Congress does not write statutes with the prolixity that answers every question, and in this instance, which involves a fishing vessel that is fishing for herring, and under the agency rule and under a congressional rule, must have federal monitors aboard. And the issue here is whether or not the controller has to spend essentially 20% of its income on paying for those federal monitors. This does seem pretty extreme, but then as the United States notes in response, there is no appropriation from Congress from this. There is a requirement to federal monitors. There's lots of instances in which essentially the industry has to pay for the monitoring and the regulation that it has. From my perspective, I know that a lot of courts, of course, charge different kinds of fees that are then plugged back into the court budget. And the challenge here is also based partially on the fact that the appropriations clause requires that any appropriation be the product of congressional action. And they say, well, this is still a product of congressional action in defense, the United States says, because, of course, they said that there must be federal monitors, and they did not appropriate for the money for it, so therefore, essentially, Congress must have assumed that we would find this kind of a solution.
I don't have much to add to Bob's very thorough explanation of these cases, but let me offer one observation. The Loper-Bright Enterprises case, I just wanted to reemphasize, very directly presents Chevron. I mean, the question presented, and it's back up and say the petitioners in that case presented several questions for the court to consider. As I understand it, they went through 5 consecutive conferences. Who knows if they discussed it at every conference, but the case sat there for a long time. And then they granted the cert petition that limited the consideration to what was the second question presented by the petitioners, which was bluntly, and I'm quoting, whether the court should overrule Chevron, or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute do not constitute an ambiguity that requires a difference. So it's very squarely presented here. The only thing I'd add is I think I noted that Justice Jackson has recused herself from this case, presumably because she sat on a panel with the EC Circuit. I don't think she was involved in the decision.
I think
But
that's
I
right.
think for that, and again, we don't know that because they don't explain the refusal, but presumably that's why. So, given the somewhat jumbled combinations on issues like these, the courts important that there are only 8 justices participating.
So, can I ask a quick question of you, John, on that? That the second half of the way that the question is phrased does allow for an interpretation of Chevron step 1, basically just a clarification of Chevron step 1, such that you don't need to decide. And so if they want to be conservative, they can actually not take the first half of that question and just say, yes, this doesn't create an ambiguity, you're allowed to use normal rules of statutory interpretation. And with that, I would ask each of you to kind of comment. The court has been looking for the ideal vehicle if they are going to overturn expressly Chevron, I think. And I wonder your thoughts on whether or not it is the ideal vehicle.
I'm not sure that it is the ideal vehicle, but I think that it is as good a vehicle as they're likely to get for quite some time. And so if the inclination is to strike down Chevron, and the arguments presented on that are very well done, this is a good vehicle.
And that question presented was artfully done by Paul on briefing on that, who I know has been focused on this issue for a long time. So, but yeah, I agree. I think this is as good as they're likely to get. As you're suggesting, there are several justices who, in other contexts, have stated their view that it should be reversed in some fashion.
And I think that this has been percolating long enough that I think there is an appetite to finally move on from Chevron. There's a second administrative law case that I also wanted to quickly cover, and that's SEC versus Charst. This comes out of the Fifth Circuit, and the question really is whether administrative law judges are constitutional. So one of the things that understand is that this has always been an odd type of arrangement where there's an adjudication before a hearing officer who is supposed to have some judicial independence, but at the same time is subject to appeal within the agency to the agency itself. That the appointment and removal process is quite different from the agency heads themselves. And so therefore the question is really, how does this work under a constitution where there is a non-delegation doctrine where Congress is supposed to make the decision? Now here the agency, of course, has the option of moving to the adjudication before an ALJ or to litigation, and that's the question, whether Congress needs to make that decision or whether Congress can authorize the agency to do so itself.
I don't think I have anything to add to that. Do you think, are you inclined to think they're going to reform what the circuit has done?
I don't think so. I think what we're going to get is a non-decision decision. So that there'll be years of additional litigation because I just don't think the court is ready to tear down everything that exists.
That's where I was headed, because if you step back, it really, particularly on the SEC side, rips out a lot of historical functioning of the agency.
I think if it were a different agency, there might have been a better appetite for that.
Shall we move to the credit reporting and sovereign immunity?
Yes, so this is a case involving the Department of Agriculture, adding to the exciting areas for discussion. And by the way, I wanted to thank you for scheduling us on Friday and having us convene right after feeding everybody barbecue for lunch. Talk about a tough audience.
Well, no other audience would be better prepared for these subjects.
Well, as a defense practitioner, I tend to think of the federal government, at least in the litigation context, as an adversary, because normally they are suing my clients or bringing enforcement actions. And so I think, like a lot of other defense practitioners, I forget about the fact that the federal government is often a civil action defendant. It gets sued a lot. Now, sovereign immunity provides, I should say, a major shield to that, but there are lots of windows. Federal Tort Claims Act and other windows allow the federal government to be sued. So there are times when we see the Solicitor General's office acting like a classic civil action defendant, and this is one of those cases. The question presented in this case is whether Congress waived sovereign immunity for violations of the Fair Credit Reporting Act, which is a very frequent source of class actions against financial institutions, retailers, and others. And in this case, a fellow by the name of Reginald Kurtz contends that although he no longer owed any money on a loan that he had obtained from the Department of Agriculture, the department nonetheless advised credit reporting agencies, in particular TransUnion, that he had an account that was 120 days overdue. Big negative if he goes to try to get another loan. And Kurtz notified TransUnion that this was an error. And under FCRA, when you've posted information and you were notified by the agency that the consumer has advised that this is an error, you've then got an obligation to address it, confirm it, deny it, change it, whatever. But that's what FCRA requires. Here, the Department of Agriculture did not correct the error. And so Mr. Kurtz filed a civil action alleging that the USDA had violated FCRA and because it failed to correct the inaccurate information. The USDA asked the federal court to dismiss the case, arguing that the language of FCRA did not express a clear congressional intent to waive government immunity, and the district court agreed and dismissed the case. On appeal, however, the Third Circuit reversed. The court focused on FCRA's definition of person, that is, persons who have obligations under the statute, and it included as part of the definition any government or governmental subdivision or agency. So the Third Circuit said, government's in. Third Circuit added that since the federal government is the nation's largest employer and creditor, allowing civil actions against it concerning FCRA violations would be consistent with the congressional desire to have this statute ensure fair and accurate credit reporting. Not surprisingly, the government petitioned for cert, and there turns out there's a fairly significant circuit split on this issue. The Fourth and Ninth Circuits have held that Congress did not unambiguously waive sovereign immunity and that FCRA claims against the government therefore are not permitted. On the other hand, the DC and the Seventh Circuits, plus this Third Circuit ruling, reached the opposite conclusion, that there is a waiver and FCRA claims against the federal government are therefore permitted. I would note, again, sounding like a corporate defendant, the SG pointed out that it was very important for the court to take this issue because it concerns a matter of great importance because of significant financial impact. So I'm reading there what you normally see in the corporation's petition to the court. The cert grant should not be a big surprise. This issue has been up to the court before, and 3 years ago, Justice Thomas dissented from a denial of cert in a case like this, and so not surprising that this came knocking on the door again and was accepted. So how will this case come out? Well, it seems to me it's basically a statutory interpretation case, and I think the Third Circuit sketched a plausible analysis. The government's there mentioned in the statute, but the respondents have a pretty heavy burden here since the statute would have to contain an unambiguous waiver, and that statutory language would have to be pretty specific. I think part of the problem is you could theorize Congress would say, we want the federal government to follow this obligation, to have this obligation, but then not be permitting a private cause of action against the government if they do not. And I think that will be the debate. I wouldn't bet a lot of money on either side of this one, and because I think it'll really turn on whether that definition of person carries the day, and the case is set to be argued on November 6th.
So my reading of the case doesn't vary very much at all from John's. What I see is that the court is going to debate what language is necessary to unambiguously waive sovereign immunity. Can you do it essentially by saying government is going to be liable when they engage in this conduct? Or do you need to say something like, and we're waiving sovereign immunity? That's essentially what it comes down to. And the textualists on the court, which I think are a majority now, and it doesn't matter ideologically where they stand, I think are going to find it hard to say that Congress did not intend to waive sovereign immunity by that language that John quoted, which defines a person as a government ordained agency. And there are some on the court who don't think very much of this particular statute. And to them, I think putting the government's feet to the fire might also encourage changes to the statute. And so that might be a secondary hope out of a decision that favors affirmance.
This is one where if the court gets it wrong, it's a pretty easy statutory fix, correct? Hey, Council Holly.
Although in Congress these days, nothing is easy.
Not true. All right, shall we move on to the next case then?
Yeah, so the next case goes to the question of whether the Consumer Financial Protection Board is constitutionally funded. So this is another instance in which the appropriation clause is at issue. As you will recall from my comments earlier, the appropriations clause really looks to Congress to make the appropriations that fund the federal government. And here, the CFPB was uniquely funded out of fees charged to banks by the Federal Reserve and then used by the Consumer Financial Protection Board. The question that comes up in the course of their attempt to enforce some of their rules against a business, and the business basically says, you know, they can't enforce any rules because they're not constitutionally funded, they should be declared unconstitutional. And the fact that the court took the case with the CFPB being the petitioner makes it very interesting, because you're not sure whether it's, you know, we're the ones who want to declare this unconstitutional, or we're going to see that, you know, there are a number of other instances in which the federal government funds things this way. What would they have to do? Would they have to, when they collect these, turn it into the Treasury and allow Congress to appropriate it, which is, of course, the position of the respondents, or can the agency essentially use that money, which would include having to transfer it into the Treasury even when Congress specifically says so. So that's the question before the court. I think this is going to be a very close question for the court, and I'm not willing to make a prediction on it simply because there's, of course, hostility on the court to the CFPB. At the same time, there's recognition that probably some of this kind of funding is necessary in some instances, and finding a way to maybe put limits on an agency is very difficult to do under these facts.
I'm not willing to go out on a limb on this one either, but I'll offer a couple of observations about it. I think we need to keep in mind that this agency and this statute were created coming out of the 2008 financial crisis, where there was this feeling on the Hill, we really got to fix this, we got to do it right. And I think there was a lot of concern that there would be a fix created that would erode over time. As people Glass-Steagall erosion and so on, prior protections, and say, we don't want this to happen again. And of course, the major way it would happen would be over time Congress cutting back financing for these activities, exercising the power of the purse in a way to reduce regulation, enforcement activity, and so on. And that's really the debate here, is whether Congress should be doing that. I found it interesting in one of the briefs that challengers to this regime say that this needs to be struck down, I'm quoting now, because a single Congress could effectively nullify the appropriations clause by passing a law authorizing the executive branch to spend as much public funds as desired in perpetuity for virtually any purpose unless and until a future Congress could overcome a presidential veto to retake its power over the purse. And I think that's the debate here. And I think the question is whether enough on the court find it to be sort of a too cute way to do this, or feel that this is a reasonable exercise. To Bob's point on petition coming from the agency, one interesting thing I noted, I don't know what to read into it, but the CFPB pressed the court hard to hear this case last term and therefore decided by now. And for whatever reason, the court did not do that. I don't know what to read into it. The court may have said, no, we'll set our own schedule. But the CFPB made a very compelling argument that said basically, look, we're stuck in the mud here. Everything we do is being challenged, as Bob said, is being done by an illegitimate agency. We need some resolution on this. But in any event, the court decided to continue to let the agency suffer. The case will be argued early on October 3rd, so I guess we'll get a result soon.
Right, so one of the observations that those of us who watch the court quite a bit note is that the longer the case is pending before the court, the more conferences it is before, the more likely, doesn't guarantee it, but the more likely cert is going to be granted. And so, while we like to think that we're reading all kinds of tea leaves into it while our cases are pending before the court, I found no pattern that necessarily guarantees my reading is any better than anyone else's. With that, there's just one quick thing that we wanted to raise. You can't talk about the upcoming Supreme Court term without talking about the ethics issue that's over the court at the moment. You've got Congress pushing for an ethics code. You've got Chief Justice Roberts guaranteeing that they're working on one, and Justice Kagan saying they're very close. And I want to make one observation about this. While it's incredibly important that justices abide by ethics, there is no good solution here. The fact of the matter is, it's very hard to define recusal in any way that basically becomes nothing more than the eye of the beholder, and since each justice will make the decision for themselves, no one is going to enforce it against them. And at the same time, if there is a violation of ethics, again, who is going to enforce it? Is the court going to act against one of their justices? I doubt that. Is it going to be assigned to the judicial conference, and is the judicial conference really going to act? No. I think we're stuck with the only idea that if there's something egregious enough, impeachment lies outside there, and that's where we stand.
Yeah, I share the concern that the focus on this issue doesn't really lead us anywhere. I'm not saying that these issues should not be raised, nor am I criticizing questions being raised about these things. I will say I do find it interesting that Congress, of all places, seems to be most interested in this issue. You kind of go, get a mirror, folks. But it does trouble me that seemingly across the board we're in this mode that there is this constant barrage of ethics criticisms being raised against all of our institutions, all three branches of government. And maybe that means we need to find some way to straighten up and fly right, as you may say, but you do sort of wonder whether the motivations for all those attacks are really trying to make us more ethical or are being made in pursuit of other objectives.
And as we approach Constitution Day in just a few days, I think this is one area where, Constitution Day is about educating the public. I think this is one area where the public needs a bit of education on the separation of powers, right? And the means by which we actually can control judges. You mentioned, for example, there is a provision in the Constitution that will allow for us to address this, but there are also limits on what Congress can do, which isn't necessarily translated into popular media on this issue.
Well, I would add to what you say is not only does the public need an education about the Constitution, but members of the government do as well. Since John referred to the fact that he represents defendants, I often represent plaintiffs who are suing the federal government.
So there were, I do want to get to questions, so there were 3 other cases that were on our wish list. Can you just mention those cases, maybe not in a summary, but just let them know that people should be able to look out for the social media and the First Amendment case?
I will mention a pair of cases that are before the court on social media issues, given how excited the court was to deal with social media last term and demonstrating that they don't spend a lot of time themselves on the internet. This case is about if a government official blocks you on their Facebook, Twitter, or whatever website, whether that's a violation of the First Amendment as government action.
So in each of these instances, these are personal social media accounts, but they are used by those government officials to announce governmental policies and accomplishments and upcoming events. And so the question is whether that basically makes them even an unauthorized mouthpiece essentially to the government.
Excellent. So we have about 5 minutes left in our official program. For those of you online, we will continue online for a little bit past the official end. And I will, again, use the Q&A question at the bottom of your screen if you'd like to ask questions. For those of you in the audience, I will start taking questions now. I will let you know that we did tell you we will end at 1:15, but both speakers agreed to stay a little bit longer. So we'll take questions past 1:15, but if you do need to leave, we understand that. Please just do so quietly so that we can continue the question and answering for those in the audience. So let's start with an audience question and to the gentleman there. And if you could stand up so you can project so that everyone can hear you, that would be helpful.
Yeah, hi, I've dealt with this kind of bounty hunter, you're talking about the hotel case. I've dealt with this kind of litigation before. And typically, there's not a lot of deep pockets or extensive appellate practices, the people who bring these kind of cases. I'm just curious, who is funding this appellate litigation and why?
Well, I think the suggestion in the papers is that it does pay for itself.
Right, but it's small potato stuff.
Oh, no, yeah. No, I'm not saying that, this is not the opioid litigation that we referred to earlier. And these are not large firms that are bringing this, these are sole practitioners. But I think that's right. But it's taking up a lot of time of the federal courts.
Right, but somebody's paying for the appellate litigation, which is probably very expensive.
Yeah, these appeals were handled by the same lawyers who, as far as I can tell, were handling the district court cases. And indeed, the certain response here was filed by the same lawyer, but he's now withdrawn from the case. Whether they're getting funding from some other source, I don't know. But it appeared to be, a self-contained business model.
Yeah, and I've got to assume that it's only volume that makes this at all economically sensible.
So it's your supposition that the solo practitioner who's subject to bar discipline is going to represent this client before the Supreme Court?
No, the case has been taken over by, I forget the name of the group that's affiliated with Georgetown. It's begun appearing, so I assume someone else will be appearing.
It's a clinic there at Georgetown.
I'm assuming that part is on a pro bono basis, but until the withdrawal, it was this woman's attorney who represented her in the district and appellate court cases, so.
So on the same case, we have a question from the audience online, and I will ask that whether you're online or in the audience, when you do ask a question, please identify yourself and also let us know your affiliation. But this one comes from an anonymous person online who says, for the standing cases, does it matter if she would have to stay at the hotel? Couldn't she be using the information for purposes other than the actual hotel stays, for example, a blog or even just a personal tracking sheet, and would still therefore have standing? I'm assuming the answer is about the zone of interest there that the statute protects, but your thoughts on that?
Yeah, the statute clearly, at least as argued in the briefing, is that the zone of interest is clearly intended to cover someone like this, and therefore they are appropriate people. The Havens, no one actually wanted that apartment that they asked about. And so therefore, it's unnecessary. What they're trying to do is enforce the requirement that there be notice about accessibility. And so at least that is the argument. But as I said, it's not one that I think the court will end up deciding.
I did want to repeat a point that I think both of us made earlier. The woman who brought these cases is within the protected class, among those who are tended to be protected by the statute. The question is whether there needs to be more than that to have standing.
Right. And then the argument is also made in the briefing that, if it had been accessible, maybe I would have considered going there, but the fact that it doesn't tell me means that I'm not going to end up considering it.
Yes, sir.
Hello, my name is Euro Sirik. I'm a 1L here at George Mason. It seemed like last term, one of the big points of discussion was the court's use of the shadow docket. Do you foresee that being another point of discussion this year, or are there any indications on where the court's going to be heading on that for this term?
Well, first of all, Justice Alito would condemn you for using the term shadow docket. But the court has gotten to use this, it's always had something that's akin to the shadow docket. The extreme use of it is what has caused us to all take particular notice. And the fact that we're getting substantive decisions out of it is the concern, without full briefing and argument. I think that's going to continue. There is some sensitivity on the court to the public criticism. Maybe it's going to be a little less, but it's still going to be substantially more than it's ever been before.
I don't think I have much to add to that, but I do think there is a sense at the court of wanting to respond to more quickly to issues they see developing. When we talked about it, it's not, wouldn't be said a shadow docket issue, but what they did with this bankruptcy case.
Yeah, I mean, it's not
interesting.
It's not unusual, and the petition to the court asking for the stay suggested that it could be used as a petition for cert. And the fact that the court wanted to do more than the stay is it. But you apply for stays all the time. I've applied to the court for stays in cases that I'm working on a petition on, and I've opposed stays from others. And the fact is, because this is the federal government doing it, by making the petition, I think it was more likely that they would go ahead and accept this as a petition as well.
Yeah, I do want to clarify in that point. I didn't mean to suggest the court decided, Blue is deciding to do this. And there's a very good reason to do it, is because if they went ahead and closed the deal, then you've got the problem, there's really no way to unwind this. If they've accepted releases or paid money and so on, it's like a corporate transaction. The court's got to do something, or it's over, you can't come back and do it later. So I don't want to suggest that, but it was very quickly done action.
And of course, in the background, you have the automatic stay under bankruptcy law that affects all litigation involving those parties. So
We have the creation of a attractive tagline that allows the media to become even more misinformed about what the court actually does, right? I want to move to a question from online. If the CFPB funding source is declared unconstitutional, what happens to prior rulings from the CFPB? This was an unnamed question.
Well,
Any retroactive effect on, or can they be reopened?
I think it would be difficult to get past any final judgment that is no longer subject to appeal or anything like that. For cases that are still open in any way, which they're within the 1 year, to ask the district court to review the judgment, if they're within the time to still seek some sort of review, then it has some effect. But I don't think you can come back to the court and say, well, we were right 5 years ago, and we should have ruled in our favor then.
Are you talking as well, though, about the regulatory regime?
I think this would encompass the regulatory regime, which has different finality concerns than say a final judgment, where the court has been pretty strict on protecting finality in terms of Article 3 judgments, but agency judgments, I suppose, are part of the question.
I assume it depends on the grounds analysis that they go through on this issue. There's certainly arguments in the briefing that everything the agency has done to date is null and void because it was improperly created in the first place. I suspect the court, and this may end up in the laps of lower courts later, will find a way that not be the outcome. But if you think about it, if you say this was never properly created, you raise questions, was any of this that they've done authorized?
Yeah, logically, you would think that all the regulations are now null and void if the court were to declare the CFPB unconstitutional. You could also see different agencies of the federal government, which might share some overlapping authority, try to reinstitute some of those regulations. You theoretically could see Congress try to reformulate the agency and allow them to reinstitute those regulations. But that's all speculation.
We have time for maybe one or two more from the audience. Yes, right in front.
Hi, Toby Radji, Washington Post. On the issue of ethics, there's a bit of a split between even the federal judges, some supporting more recusal guidelines for the Supreme Court, others strongly opposing it, especially in Congress. There's a split along party lines. And for me personally, I just want to get a better sense of what the atmosphere is like amongst the lawyers who argue for the Supreme Court, if there's debate about this amongst themselves as well or not.
Please repeat that question.
Yeah. The basic question is whether the ethics issue that is taking so much time of the justice speaking publicly and Congress talking about it is something of debate of those of us who practice before that court. And it's inevitable that we would all be talking about it. There have been instances where there has been filings in the court about recusal, the duck hunting incident with Justice Scalia, for example, and things like that. But the fact of the matter is, each justice is considered to basically be an island of their own and make their own decisions on when they recuse. Their differences are more than the strike zone of a baseball umpire. You have Justice Kagan refusing bagels and cream cheese from her friends, and other times you've got the recent decision by Justice Alito about how he is not recusing himself, and that's clearly on a different dimension. And this has always been true. I was part of a project of the National Center for State Courts, which provides advice and legal assistance to the Conference of Chief Justices, which is the Chief Justice of all states. They came up with their own sort of basic model for how recusal might occur, but some of the chiefs said, in our state, it is up to each justice. It doesn't matter, I have no power over them. I'm not even the first among equals, and so therefore, I'm never going to be able to say anything about other than, this one looks like one you should sit out, and they'll say, I don't work for you.
I think as Bob was suggesting earlier, there is a lot of concern about practitioners, about all of this noise that is going on the ethics issue. And as I said before, I don't want to suggest that it's inappropriate for people to raise these things, but as a practitioner before the Supreme Court or any court, I think you quickly realize this is the court. This is the court that's going to make decisions. This is the system in which we operate. And we need, as practitioners, to respect that. These are going to be the decision makers. And you cannot get preoccupied about what may be motivating a particular judge to reach certain decisions. You've got to make your arguments to the court, and that is the person or the persons who are going to make the decision. And you cannot get off on a sidetrack worrying about those sorts of outside influences. That's not saying they're inappropriate public discussion, but as a practitioner, you just can't function in that environment if you're constantly questioning the bona fides of the decision makers.
The Supreme Court, what you do is you deal with the justices that you have up there. You're trying to make arguments that pull enough of them over to your side. On other courts, when you appear, whether it's a Court of Appeals or State Supreme Court, you sometimes have a pretty good idea whether they're going to be for you or not, and you do your best regardless of that.
In the back.
Yeah.
Stand up, please, and identify yourself.
My name is Caleb Dees with the Washington Examiner, and I just wanted to ask a quick question about the Rahimi case, if we even can talk about it. I know we didn't mention it. I don't think we did we?
The Rahimi case.
It's coming off of the major decision in Bruin last year, and the Fifth Circuit essentially held that this federal statute that prevents those subject to a civil domestic violence restraining order, basically they invalidated that statute, holding that if you were under one of these restraining orders and say I guess you're not accused of any violent crimes, then you could carry a firearm. Now the plaintiff in this case is like an insane criminal. He has a lot of actions he's done, like where he's like shot guns in public and things like that. He's been charged on those separate charges, but he is facing a domestic violence restraining order. Like the question is like if that's like the only thing that's that's facing you as a citizen, like should that be the thing that prevents you from being able to possess a firearm? And I thought that was a really interesting case that's coming up this term, and I just wanted to know, like, it seems like it's going to be one of those difficult ones to balance between like Second Amendment rights and someone's protecting the public. So
right. Well, Bruin rejected any kind of balancing test, and so as a result, I don't think the court, or at least the Bruin majority, is going to care about the impact. They may take a straightforward look at, as they do, text, history, and tradition. And we know that justices, when they rely on that, often pick and choose the text, history, and tradition that they think is most telling. As Justice Breyer dissented in Bruin and said, it's a matter of picking out your friends from the crowd. So I find this one hard to predict which history they're going to find influential. But I certainly do not think that they're going to step away from Bruin or the Bruin test.
So I usually like to end these with a question about some of your predictions about pending cert petitions and or other cases that you see percolating out there. And it just so happens that was also the question from someone online. So the question online is, are there any pending petitions we should be watching that you think are likely to be granted? And in our last 3 minutes here, any petitions that we should be watching is sort of one thing, and then anything else you think we should be considering as we observe the court in the coming year?
I haven't really looked very carefully at the pending petitions. I do think that there are some issues that are percolating up that are likely to end up in the court. Just earlier this week, the Second Circuit found that there's no personal jurisdiction over terrorist organizations. In this instance, it was the PLO and the PA, over the murder of Americans abroad, despite the fact that Congress had passed the statute and basically found that the prerequisites to that the statute contained were insufficient to meet due process. That's a case that I'm watching simply because the court did in the spring reject a petition I had on a personal jurisdiction statute that dealt with transnational issues. In this instance, it was Navy personnel who were killed or injured in the Sea of Japan when their destroyer crashed into a cargo ship. And we thought that under Rule 4K2, there was sufficient jurisdiction. We met all the prerequisites of that. The court still said, the Fifth Circuit en banc, 12-5 majority, said that we still need to fit this within the rubrics of either general or specific jurisdiction. We argued this was a different form of jurisdiction that could be authorized by Congress and was. So I think that issue of how far Congress can go in terms of authorizing that kind of reach is a very live issue that the court may well address.
I don't have any specific pending cert petitions to point to, but I did want to make one observation about the cert petitions generally, and that is if you look at the number of cases being accepted by the court that continues to fall. Again, we don't have a full calendar for this term, and the court may catch up, but we're going into the term with less in the hopper there than we normally see. And I can't back it up empirically, but it struck me in looking through the cases where cert had been granted. It seems to me there's a greater tolerance of splits developing. I mean, you heard our summary in some of these cases of 6, 7, 8 circuits dividing, and prior cert petitions have come up. There may be 1 or 2 justices who say we think we should hear this, but there seems to be, maybe the word is patience, maybe the word is deferral. You can use both. Not taking cases quite as quickly, and you do kind of wonder what are they waiting for, because if splits develop, it's not going to fix itself over time.
Yeah, my own speculation is to go back to something that Justice Brennan used to say, and that is while it only takes 4 votes to grant a cert petition, you don't vote to grant a petition unless you can count to 5.
Excellent. Well, we appreciate all of you joining us. Again, this was a panel brought to you by the Law and Economics Center here at George Mason University's Antonin Scalia Law School. We will continue to have programming like this, both in person and live, on the webinars. Please visit masonlec.org. That's masonlec.org to learn more about all of that. There's lots going on around the Scalia Law School as well, and I want to point out that on Monday, to celebrate Constitution Day, we will be hosting a program, a viewing of Judge Douglas Ginsburg's new documentary, We Hold These Truths. And it's a new documentary available on PBS to celebrate Constitution Day, and we will have a viewing in our multi-purpose room here at Scalia Law on Monday evening. So please go ahead and go to the Scalia Law website to learn more about that and to register. With that, we are at a close. I would like to thank the LEC staff for putting this together. So Heather Vignali in the back is our events coordinator and put much of this together. Gwendolyn Watson is our program assistant for the Civil Justice Academy. Not here today, but organizing much of this program was Angelica Sisson, who is our program coordinator for the AGEP. And helping out today is Ashley Everett George, who is our Associate Director of the Judicial Education Program. So we can't do any of this without the support of our staff. And we also can't do this without the volunteers that come to share their wisdom with us. And so to John Beisner and to Bob Peck, I thank you for your steadfast support of the Law and Economics Center and so much of our programming, including coming up to do a similar kind of preview for our Civil Justice Symposium, which will be in November. So with that, we are adjourned. I will thank each of you as we all clap out. So thanks again.